and welcome to Verdictum. I am Ananya Singh and you're watching today's legal news, where we update you with the recent important legal developments across the nation. Here are the headlines. Day 12 of the Supreme Court hearing pleas challenging the abrogation of Article 370. Allahabad High Court adjourns Gyanvapi case hearing till September 12th. Tamil Nadu Government to allocate 3 crore rupees for translation of Madras High Court judgments to Tamil. CUET not compulsory for central universities. Centre files reply on PIL against CLAT-based admissions. Haryana Government announces 20% reservation in promotions for Group A and B officials belonging to the SC category. Now let's take a detailed look at the headlines. A 5-judge constitution bench of the Supreme Court, comprising the Chief Justice of India D.Y. Chandrachud, along with Justice S.K. Kaul, Justice Sanjeev Khanna, Justice B.R. Gavai and Justice Suryakant, heard the pleas challenging the abrogation of Article 370 for the 12th day today. The hearing in the matter began on August 2nd, and so far the arguments of the petitioners have been heard by the Apex Court. And presently, the Attorney General of India and the Solicitor General are appearing for the Union of India. Yesterday, on day 11 of the hearing, Solicitor General Tushar Mehta submitted that Article 35A gave special rights only to the permanent residents of the erstwhile state and was discriminatory. On this, the CJI D.Y. Chandrachud made an interesting observation and remarked that by enacting Article 35A, fundamental rights of equality, liberty to practice profession in any part of the country and others were virtually taken away. Today, the Solicitor General continued with his arguments. He covered 3 points. First, the correct interpretation of Article 370. Second, the State Reorganization Act. And third, the parameters of powers of legislature during the proclamation under Article 356 is in force. He took the bench through the Madhav Rao Scindia case, wherein the government withdrew privy purses from the princely states, and highlighted that Articles 291 and 362 dealt with privy purses and were withdrawn by exercising the powers under Article 366. After the judgment of Madhav Rao Scindia, a constitutional amendment was made as the court ruled that Article 366 route could not be taken. The government's move was then challenged in the Raghunath Rao Ganpat Rao case, and the court held that any change in the constitution which brings everyone at par can never be faulted. And thus the princely states lost their special privilege, and the word fraternity had to be given meaning. The SG further highlighted that Article 370 Clause 3 has an inbuilt extinguishing provision. SG Mehta remarked that this argument, based on the ground of breaking the solemn pledges and breach of promise, cannot stand much scrutiny. To say that without voluntary accession, India would be different from that Bharat that came into being prior to the accession is untenable. Chief Justice Pritinkar Divakar of the Allahabad High Court adjourned the hearing of the Gyanvapi mosque dispute till September 12th. The present petition challenges the maintainability of the original suit filed before a Varanasi court. The plea sought the restoration of Lord Visheshwar Temple at the site where the Gyanvapi mosque presently exists. Another petition that challenges the Varanasi court order of 2021 to conduct the scientific survey on the mosque premises by the Archaeological Survey of India has also been clubbed with the present petition. Both the petitions were being heard by a single judge bench comprising Justice Prakash Padya since the last 2 years. The final hearing before Justice Padya was conducted on July 25th this year, and he fixed August 28th as the date for the delivery of judgment. The case was, however, listed before the Chief Justice yesterday. When the CJ started the hearing of the case, the Anjuman Intizamiya Mosque Management Committee, responsible for the management of the Gyanvapi Mosque, made a request that the case be heard by the same bench that had heard and reserved the judgment in the matter previously. The Chief Justice, however, said that according to the High Court rules, when the judgment is not delivered, even after the hearing in the matter has been completed, the case stands released to the Chief Justice, being master of the roster. And it is the Chief Justice who has the power to either send the case to another bench or hear it himself. The CJ also highlighted that since March 2021, the judgment has been reserved several times, but not delivered. On this, the Council for the Mosque Management Committee sought an adjournment to study the case afresh. The CJ accepted the request and adjourned the matter till September 12th. The Tamil Nadu government has announced that it will be allocating rupees 3 crores to the State Official Language Legislative Commission for translating the judgments of the Madras High Court from English to Tamil. The announcement was made by the Chief Minister of Tamil Nadu, M.K. Stalin, who said that the allocation of funds is in line with the Tamil Nadu government's position that Tamil should be made the official language of the Madras High Court. The move aims to support the translation efforts and promote the use of Tamil in the legal system. The centre responded to a public interest litigation filed before the High Court of Delhi against the admissions in the University of Delhi to the 5-year integrated law course, being solely based on the common law admission test results. A division bench of the Delhi High Court comprising the Chief Justice Satish Chandra Sharma and Justice Sanjeev Narula were informed by the centre that the CUET, that is the Common University Entrance Test, is not compulsory for the central universities, and they enjoy autonomy in the matter of admission. On August 17th, the High Court had told the Delhi University that when other central universities grant admission on the basis of the CUET score, the University of Delhi was not special to make admissions based entirely on the CLAT 2023 result. The University Grants Commission has, however, taken a different stand and submitted that it is mandatory for the central universities to adhere to the CUET score for admission to both undergraduate and postgraduate courses. The High Court has granted both the UGC and the centre time to file a detailed counter affidavit in the case and has listed the matter for September 12th for further hearing. Haryana Chief Minister Manohar Lal Khattar has announced that the government is all set to implement a 20% reservation policy in promotion of Group A and B officials from the scheduled caste category. Previously, the policy of such reservation was limited to Group C and D posts. The CM said that the new reservation policy will extend the reservation benefits to all stages of promotion, ensuring continued support and representation for the reserved communities in government jobs at all levels. That was all on today's legal news. Thank you and keep watching Verdictum, and subscribe to our channel and download the Verdictum app on iOS and Android to keep yourself updated with authentic legal news.